Owens is not gonna be here, because of Renee's problem. It looks like you need to take the seat.
Up here.
Please.
Is there somebody's phone number in, like, cause I didn't think I was gonna be able to come, and I
Call me,
called John
call me.
again?
Yeah. You want my number?
Yes, sir. Just tell you what. Just write it right there.
Listen,
Oh, well, I got a pen.
I've come prepared, not very prepared. Cause I'm gonna throw a monkey wrench in tonight's plan anyway. Thank you.
Yeah, I know you done already schooled me on that one.
336 260 0668.
00608.
0668. No, another six.
Oh, another six?
Mhm.
Oh,
Eight.
and an eight. Okay.
260.
Some combination of 0, 6s and 8s to get.
Let's start the meeting out with a prayer. Almighty God, we thank you for letting us be here. Grant us wisdom in what's going to take place tonight. And we thank you for our Lord Jesus Christ, our Savior. In Jesus Christ's name we pray. Amen.
Amen.
The first order of business tonight is the approval of our June 19th, 2025 minutes. I trust everyone's had an opportunity to review them. They were emailed to us last Thursday, I believe. I'll be glad to entertain a motion.
So moved. Second.
There's a motion and a second. Is there any discussion concerning our minutes of the June 19th, 2025 meeting? No discussion. All in favor, say aye.
Aye.
All opposed? Let the record show it was unanimous. We discussed at our last meeting some potential changes. I'm getting ahead here. We approved at our last meeting a variance for a RV park. I believe it was case number 2025-001. Even though we've taken action on that, I wanted to sign this deal in front of you guys. So if you had any question about it, this will be forwarded on to Mr. Prevet that says that everything passed okay.
Quick question.
Yes, sir.
Do you need to swear the additional member in
No.
before we get too far in?
He
Okay.
was sworn in by county staff
Okay.
last
Okay.
time. Good question. Let me take a second for you to get these signed.
Yeah, I'll just note as you're looking at that and signing it, so the actual transcript of the variance hearing is both in the minutes and in the final decision. It's really just a duplicate. It's verbatim, the exact same language. The difference with the decision is it is the application, it's the transcript of the hearing, it is all of the documents that were mailed to you initially for the hearing, and then the supplementary documents that came later as well. That includes the email from the fire marshal and then the photos that the applicants presented during the hearing, which were approved and accepted by the board. That makes up the totality of the case, of the documentary evidence.
Okay, I'm going to sign this as chairman. And today is the 17th, I believe.
It is.
My mother's birthday.
Happy birthday, Mom.
I just had one 5 days ago.
Happy birthday, Alec.
Thank you. There you go, Matthew.
Thank you.
Okay. Under new business, at our last meeting, I made some suggestions of things that needed to be changed or added to our rules of operation. I hope everyone had an opportunity to review those changes. Let's see if we can find them in here.
I don't have the This is the one from,
Can you bring that up on the screen? It should be page 25 of the agenda packet.
because this one was, from the last time.
Yeah, I asked Matthew tonight in the future to always mail us out a packet rather than email.
Did you mail one? I didn't get one.
No, in both my emails, I said, if you want a hard copy, just let me know.
Yeah, and then I was thinking of
But in the
it.
future, we'll make sure we just go in print.
I'm sorry.
Thank you.
Well, I just try to avoid duplicates
Yeah,
if we can, and just save extra printing if we don't have. to.
yeah. I can just do it on the board, I think.
Basically, what we're talking about with the Article 1 meetings, Section 1.2 annual meetings, the board shall meet every January. I suggested, if you'll recall, that we needed to meet in January because at the end of the year, the present board dies. The chair and vice chair dies with the calendar year. And in the future, there'll be new members coming on every January. And so I think that it should be mandated, and that's what this first deal's doing, section 1.2. And then section 5.5 is concerning decisions being rendered in a hurry or properly. You know, same thing sort of applies with the January meeting. You know, if we have a meeting with somebody, it could be money to them. They may need, you know, to get everything back to them ASAP. And I'm uncomfortable signing off on everything until the board makes a motion and passes on the recorded minutes where we granted that variance if that was the case. And so this gives the opportunity for the rules of procedure to tell us that we have to meet within a certain timeline. And that's what this says.
The next regularly scheduled meeting.
Yeah, right. And so therefore they should be about 30 days, generally speaking. Is there any discussion on this? If not, I'll be glad to entertain a motion. We've already, I guess I should say, we've already voted on everything else in the rules of procedure. This is just a couple of minor changes that's being made.
Yeah, I'll just say for, Keyshawn, if you can scroll down to the page 5 at the end of the rules of procedure there, just in terms of the formatting and what you're looking at here. So I've highlighted the portions that will be changed. And then the actual change is standard legal format, strike through the old text and underline the new text. So this section here, 5.5, would be a completely new addition to the rules. And basically, as Chairman Holt mentioned, would just require that after the board makes the final decision on the variance, you meet the very next meeting in order to approve it and get the decision out the door for the sake of the applicant.
I think that's just good.
And I put this in there too. I just thought it might be good to have that, to make sure that the intent here is not to
Right.
override, annul, or otherwise alter the provisions of 160D 406J. And
Yeah.
that's the provision of state law that talks about.
Just makes it legal.
Yes. And I did that a little bit with the situation in mind of a variance hearing may in the future take multiple meetings.
Right,
If it's a particularly complex case,
right,
it may take 2 or 3 meetings to dispense with the business. But
right.
that's why the language says when you render a final decision.
Yes. That's good. Mike?
Just this sentence that says where the board shall adopt a schedule for the coming year.
We,
To what degree is that just say we'll have one monthly and then we'll have to adjust it according to what's coming across the desk?
well, no, not really. What we need to do is set a date because since we meet in this room, we have to do it at a time that the commissioners are not here.
Right.
So we adopted at our last meeting, you know, the official dates for 2025. So it just gives everybody, Matthew.
Gives you a plan to work with,
Yeah,
but it's
yeah.
not chiseled in stone. Is that what
Well, it
you're
doesn't mean that we can't have another meeting.
Or council meeting as
No.
we have done this year because there's no business.
It does, that's right. It doesn't mean that we can't do any other way. It just means those are the stated dates for Matthew. If Matthew has somebody that's talking to him about a variance, he can say, well, we can do this on January 23rd.
Makes sense.
That's our next meeting. Or so on. So it just makes it a little bit easier for a way to do business.
Is there any provisions for a special call meeting like the do with planning board? Is that it?
Yeah, you can do a specially called meeting. You just may have to do a public notice. And that's spelled out in general statute.
Yeah, I believe the chairman has that authority.
Yeah, and I think you could even, let's say you began a meeting and didn't finish with all of the business, then if you made a motion to continue to a date certain, I think you'd be protected
Yeah.
without having to do any special
All that's covered in
public
here.
notices.
Did you get your copy of this? Okay. You forgot them last time. How about this time? Forgot them again?
I forgot to do
I would highly suggest going through this. It really, it gets complicated, but it will let you know how important our job is and how heavily regulated our job is. We just, one of the things that's hard for me, and I know it is my friend Mike, sometimes you can't necessarily, on this board, you can't really go with just the way your heart feels, even though you may, sympathize with the person. It's like I said at our last meeting, one of the things that we have to think about too is setting the precedence for something. Now, I think we did a good job last time in granting that person their variance request. I think it was, I think it was, no question in my mind about that. But as Matthew alluded to earlier, some of our decisions could get really complicated, not necessarily our decision, but some of the information that's presented to us. For example, and I went over this with Matthew the other day on the phone when Lawson Brown presented the board with his packet last time. Well, we hadn't seen that before, and so I was not comfortable accepting what his suggestions to the board was. Now, if we had had it beforehand and had time to study what he was asking to do, I'd have probably went along with it okay. But instead, the pictures, that's the reason I asked Mr. Brevet if he took those pictures himself, because I thought they were important. So that's the reason I allowed the pictures, but didn't allow what Mr. Brown presented to us, because we hadn't had time to study it. This book will tell you when you go through it that the chairman can actually pause the meeting for us to read things or go into a recess, I guess would be a better way to say it, so we can actually study issue. The two variances, and quite likely it'll be the case for a long time, has been pretty simple. But, if you get some New York lawyer coming in here representing Ford Motor Company that's wanting to do something in the county, then it could get complicated. So, this is an important board. This is an important board. It's a lot different board than what people think. Any further discussions? Then I'll be glad to entertain that motion.
I'll move to approve what you have here as far as your changes to,
The rules of procedure. Okay, that being specifically section 1.2
5 point.
and a new section being 5.5. Okay, is there a second?
Second.
There is a motion and a second that we change and add to the rules of procedure concerning the operation of the Board of Adjustment for Alamance County. Is that properly stated?
Yes.
Okay, any discussion? Okay, there's a motion and a second. All in favor, say aye. All opposed? Let the record show it was unanimous. Okay. The second part of our new business, I'm gonna throw a monkey wrench in. And the reason I'm going to do it is because I think the chairman's job, one of the things the chairman's job is to make sure that in the event that he's not able to be here, the vice chair can pick up. And therefore, since Mr. Cobb is the vice chair, I'm gonna play hooky and sit out there, and I'm not gonna say a word unless I'm asked by Mr. Cobb.
Just leave your stuff right there.
And then because I think this is good for the board. That's where I'm coming. I'm not saying that I think I'm the best at it or that I'm well versed at it.
There's just one thing to consider, since we only have five, and we are gonna do a mock variance, it's best to have a full complement of board members, because the decisions have to be a 4/5 vote. You may have a situation where you only have four, and in that case, it would have to be a unanimous decision. You may, instead of completely coming off, just switch seats maybe, if you're interested in going that route. Just really kind of let Ray run it
I
without,
believe that'd be the same.
without a
difference.
lot of,
That's really the same difference, isn't it?
I'm comfortable right here. You can just stay put right there.
Okay, I think that's the same difference.
okay,
Yeah, I'll agree to do that.
just let it.
What I'm doing here to let everybody know, I just think it's a good idea for this board, if I can't be here, for somebody to be, not to be too nervous about it, because, and I know Ray can do it, so. Anyway, Mr. Chairman.
No, this is a little different than planning board.
It is.
Matthew, what do you have for us to look at
Are
tonight?
can you allow me to share my screen? Okay.
Sure.
Can you close out the chat there? All right, perfect. So I'm gonna give you a presentation. I may stand if that's okay, since I'm gonna talk here for quite a few minutes. It might just be better for me to stand.
Before you get into it, maybe I
Yeah.
need to swear in anybody that's gonna be participating
Well,
tonight.
so the presentation is going to be general information about Board of
Right.
Adjustment, general statutes, things of that nature. About 2/3 of the way in, that's when we'll get to the variance and the appeals case.
Okay,
So at that point, that's when you put on your chairman hat and we go through the whole official channel.
let's do
For
it.
the first kind of 2/3, you can just sit back and relax and take a look at this information that I prepared.
Okay,
All right.
yes, sir.
I'm gonna speak up here. I think for Ray's benefit, we need to start this out just like it's walking through the door. Rather than going right into these appeals. I think it would be good experience for him
Yeah.
to go through the procedures of what needs to be done. That don't mean you have to say everything's out specific,
Right.
but and I'm not trying to put you on the spot here. I'm not trying to put you on the spot because I know I throwed it on you all of a sudden today,
I had no warning.
but it could happen.
Yeah.
That's my point. It could happen.
There's a stopping point in the presentation where kind of the general information ends. And we say, okay, now we're gonna get into the mock
Yeah,
variance.
that's what I'm saying.
So that'd
So
be a
you
good,
need to call the meeting to order.
Mm-hmm.
You need to really go through the procedures a bit.
All right,
And then, as you said, see if all the members are present, if anybody's got any problems, a
Mhm.
potential conflict. I
And
think
now
it's good for you to,
that would come up right before he got into it, right?
yes,
Okay,
yes.
all right,
Or now what I done that two different ways. In our first variance, I asked about the conflict first. But I thought about that. And so the second variance, I waited until Scott made his presentation. That way, all the members of the board realized exactly what we, And I thought, because it's really immaterial, I think, at either point when you do that. So I thought it was better to wait.
all right. So you marking this thing up for real. We're going from Jump Street. It'll be all right.
Go for it.
All right, I'd like to call the July 17th Board of Adjustment meeting to order. Has everybody had opportunity to look over old business? Motion. We have a motion.
Do we need a motion?
We're gonna do it just because.
Okay.
Motion to approve.
We need a second.
Second.
I do.
All those in favor signify aye.
Uh,
Opposed, no. Motion carries. So that brings us to new business. Mr. Hoagland,
Yes, sir.
what do you have for us, sir?
Thank you, Mr. Vice Chair. So I've got a presentation, mostly targeted for our new board members and alternates. I know that three of you previously sat in for this when the board was first constructed back in late 2023 and early 2024. So a lot of it is going to be repeat information, but repetition is the key to memory, right? So you're going to see some stuff that you're familiar with, but that's probably not a good idea. Or not a bad idea. And I'm certainly happy to take any questions or elaborate as we go through the PowerPoint and the different slides here. So this is what I plan to cover. It's really kind of broken down into two parts, 1 through 4. We're going to talk about types of local government decisions and how this board makes quasi judicial decisions. We're going to talk about important general statutes and the regulatory authority that kind of surrounds this board. We're going to talk about the conduct of a hearing, any quasi judicial hearing, whether that's a variance or an appeal. That's where we'll get to with point 4. There'll kind of be a stop at that point. And then with 5 and 6, that's when you're going to go through the mock variance. Once the mock variance is over, go through the mock appeal. And then at the end, whether you have questions about the procedure, the general statutes, anything we covered, anything we might need to go over, that's when I will be glad to go over that again with you. All right, so just starting off, so big picture in terms of the authority that the state of North Carolina gives to local governments when it comes to your types of decisions, when it comes to the land use regulatory authority. It's really broken down into 3 different types of decisions: legislative decisions, administrative decisions, and quasi judicial decisions. Now, I put the advisory recommendations in there for a couple of reasons. Advisory recommendations are what you guys are probably or have been historically most familiar with on the planning board. Planning boards typically take a look at applications, especially if they're complex. In jurisdictions with zoning, they'll make a recommendation on zoning approval, and then ultimately it goes to the county commissioners. The county commissioners make the legislative decisions. So just going through those one by one. Legislative decisions, again, those are decisions made by county commissions, town councils, board of aldermen. These bodies make the final decision about what the local law will be in that jurisdiction, right? They're basically the Congress of Alamance County or the city of Graham or whatever it is. They make the final decision. Again, the planning board often makes those types of recommendations, but they simply make an advisory recommendation. The county commission has the ultimate authority. Administrative decisions are the type of decisions that I make. Somebody submits a subdivision plat, somebody submits a proposal. We make sure that it's in line with the Unified Development Ordinance. And if it is, sometimes it's a really long, lengthy process. Sometimes it's a relatively short process. But those are permits and other decisions filtered through the ordinance that administrators make on a daily basis. This ordinance empowers us to make those decisions. Thank you very much. I know you need a copy of this. I guess Renee needed the other, right? Those are administrative decisions.
could I possibly get Renee's? Mine got burned up. I
Okay.
had fire in my office and I don't have a copy of it.
You got it. Absolutely.
Thank you.
So then we get to quasi judicial decisions. These are almost always reserved for a board of adjustment. These are variances that you've heard now a couple. Appeals of administrative decisions. So if I make a decision, we make a decision, and somebody doesn't like it, they can appeal it to this board. And special use permits. Those are not utilized in Alamance County, but they may be in the future. They're utilized in jurisdictions all over the state of North Carolina. Sometimes governing boards who make the legislative decisions equip themselves as boards of adjustment. They go into a special session and then they make quasi judicial decisions. Here now in Alamance County,
You got a call.
we have an independent board of adjustment that the county commissioners created about a year and a half ago. And that's why you're here. So what is a quasi judicial decision? So this is taken just verbatim from the general statutes, and it's obviously very wordy, and a lot of this I'll just try to summarize, but feel free to stop me if you want to get into the details. So a quasi judicial decision is a decision involving findings of facts regarding a specific application of a development regulation that requires the exercise of discretion when applying the standards of the regulation. The term includes but is not limited to decisions involving variances, special use permits, certificates of appropriateness, and appeals of administrative determinations. So that definition there, and then kind of going back to this a little bit, why does this type of decision exist, right? Why has the General Assembly enabled local governments to make these types of quasi judicial decisions and then define them the way that they have? Big picture, I think you can think about it this way. The General Assembly says over the many years that they've dealt with this issue and in their infinite wisdom, local governments, we're going to give you planning and zoning and subdivision and land development authority. We're going to trust you to craft your ordinances, and we're going to trust you to deal with all these issues. And most likely 95, 96, 97, 8, 9% of the time, your rules are going to be just fine for whatever you got going on there. But that 1% of the time, an application is going to come in, and because of your rules, a property owner is going to have a specific hardship. They may have a narrowing of their clearway on their RV park, right? The rules don't necessarily fit in all situations. That's when somebody might apply for a variance. That's a quasi judicial decision or a quasi judicial process. So what is a board of adjustment? A local government may by ordinance, which we have, provide for the appointment and compensation of a board of adjustment consisting of 5 or more members, each appointed for 3-year terms. The governing board may appoint and provide compensation for alternate members to serve on the board in cases of absence or temporary disqualification if any of the regular members or to fill a vacancy pending another appointment. The duty shall include to hear and decide matters upon which it is required to pass under the statute or development regulation adopted under this chapter. The board shall, let me make sure I got this thing in my way here, comply with all the procedures and processes applicable to a board of adjustment in making a quasi judicial decision. So whether it's an independent board of adjustment like you or another body acting as a board of adjustment, you still have to abide by the same regulatory framework. Okay, so I know that we've covered, well, I'll get to that in just a moment. So this is a kind of a bullet point of the important statutes and regulations that govern what you do. When you guys were first appointed, I think I sent out an email and created a link to these documents, these general statutes, kind of all in one place. And I know when the other board members were first seated, we shared these with you as well. But it's always worth repeating. So section 102 defines what is a quasi judicial decision. We've already gone over that. We've already gone over the establishment of the Board of Adjustment. Article 4, or Part 4 and Part 7 really get into the meat of process, quasi judicial procedures, and quasi judicial decisions and variances. So breaking down General Statute 160D-406 for quasi judicial procedures. The first part is that the process is required, and that process is that you must follow a quasi judicial procedure. That is a certain procedures by which administrative materials are delivered, people qualifying by taking oaths, only allowing certain witnesses and certain persons to testify. We'll go over more details as we go through here. The notice of the hearing must be mailed to the applicant or the appellant and to all adjoining property owners, and there must be a sign posted at the site. If you looked in the application that they submitted for the previous variance, we had dates on there in which we administratively went out to the property and posted a sign and mailed notice to the property owners. The administrative materials, so these have to be provided to the board and to the applicant contemporaneously. This actually came up during our last hearing, or during our last procedure. If you'll recall, I had sent you the entire variance packet, and then the applicant said, well, we would really like to see something from the fire marshal, communicated with the fire marshal. And then as a result, there was an email that included the language or the testimony from the fire marshal. As soon as that email hit my inbox, it became part of your suite of evidence. That evidence had to be sent out to all parties involved in a timely manner. That's why you got it immediately. And at the same time that the applicant did. Presentation of evidence, so we'll get into this a little bit later, but only parties with standing may participate in a hearing. And I believe it's 1402C that specifically spells out who has standing. And witnesses may present competent material and substantial evidence that is not repetitive. So Mr. Holt alluded to this earlier, but it's different than your public comment section at a planning board meeting, right? Somebody, it's not really appropriate in these types of settings for somebody to come and say, well, you know, that guy, I loaned him my truck 15 years ago. He told me he's going to fill it up with gas, came back, it didn't have any gas in it. I wouldn't trust him at all. I wouldn't approve this if I were you guys. You just can't really entertain that type of subjective, unsubstantiated evidence in these types of hearings.
If I might intercede here.
Yes, sir.
At our first variance hearing, I remember Mike Owens, he questioned me. There was a couple of people that I didn't feel like they had standing. And that's a chairman's decision, but it can be appealed to the entire board. And Mike disagreed with me. Mike, but his motion, I don't even think he ever made a motion. But anyway, where I was coming from with that, just to follow up what he was saying, because this might happen again, is the issue of standing is important. It's got to be factual. That's like what he was saying, you know, if somebody, just because they're a neighbor doesn't necessarily give them standing. You know, if one of those people, I get a little bit more specific, and I know we don't want to be here all night, but what they were a neighbor and they were afraid it might hurt the value of their property. Well, that's fine, and I agree with that in theory, but the truth was that they didn't have no proof of anything like that, you know. So therefore, I didn't feel like they had standing, and it was a sort of an iffy kind of deal, you know. And Mike took issue with it, you know, and I feel on this board, just like I did the planning board, we all need to agree to disagree, you know, when we discuss things, you know, it's okay to disagree. And so it can come up. That's my point. It can come up.
Mhm. Absolutely, yeah. Yeah, anytime we've discussed this and received training at the UNC School of Government, you know, they say something like, people will come to a hearing and they'll say, if this is approved, it's going to deteriorate all of our property values. Okay. Well, that's really, if you're just kind of a neighbor who doesn't want it to be passed, that's really just kind of conjecture. Do you have an appraiser who can certify, who has analysis and who has
Right.
data that say this may deteriorate property values?
That's right.
With regards to traffic, do you have a traffic engineer who can certify to, you know, trips per day or increase traffic amounts or parking issues or something like that? So it's not that you can't entertain it, but it really has to be, you know, certifiable, data-driven testimony, often provided by experts.
That's the reason, Mike, I was saying earlier, this it's a quasi judicial deal. We've got to be right when we do things, because if we don't, if it goes to Superior Court, then there's a problem for the county.
Matthew, can I jump in
Yes,
for
sir.
a second?
Yeah, absolutely.
All right, so everybody's here tonight. I served on the planning board, each and every one of you. Planning board is completely different than board of adjustment, completely different. Board, planning board, we can sit there and debate each other. We can make suggestions. Board of adjustments, we have to enforce the letter of the law. That's what we do. It's just like being in a courtroom. We cannot listen to hearsay. And it's like Matthew and Ike was saying, you have to have standing, and it has to be factual. It has to be able to be backed up. It's the same as if we're all sitting up here with black robes on and a big white curly wig.
That's right.
So we have to look at the facts.
All right, so we've talked a good bit about standing. Well, what is standing and who has it, right? That's the next question. So it is found, the specific guidelines found in 160D-1402C. A petition may be filed under this section only by a petitioner who has standing to challenge the decision being appealed. The following persons have standing to file a petition under this section. Number one, any person possessing any of the following: an ownership interest in the property that is subject to the decision, a leasehold interest in the property that is subject to the decision, or an interest created by an easement, restriction, or covenant in the property that is subject to the decision being appealed. That last one's fascinating because you actually will get homeowners associations that are not even maybe directly related. It could be one property down at the end of the cul-de-sac, but the chairman of the homeowners association may say, we have standing, and he's all the way on the other side of the neighborhood, and they can participate in the hearing by virtue of that connection. B, an option or contract to purchase the property that is subject to the decision. And C, an applicant before the decision-making board whose decision is being appealed. So in other words, the applicant themselves. But it goes on. Number two, any person who will suffer special damages as a result of the decision being appealed. Now, this is where it can get a little bit tricky. And it kind of goes back to what we previously talked about with somebody just providing maybe some hearsay, right? If you approve this and this business comes in next door, they're going to have tractors and trucks running all day and night. I live right next door. I'm not going to be able to sleep at night. I'm going to suffer special damages that are unique to me because I'm going to have to put up with the sounds of these engines all night. Nobody else is. Do you accept that as testimony before the board? That's a decision you'll have to make, right?
Chairman's decision.
Right. Three, an incorporated or unincorporated association to which owners or lessees of the property are designated by virtue of their owning or leasing the property, similar to the association we talked about earlier. And there's some other details in there. And then number four, a local government whose decision-making board has made a decision that the governing board believes improperly grants a variance from or is otherwise inconsistent with the proper interpretation of a development regulation adopted by the governing board. So in other words, if the powers that be don't like the decision that y'all have made, they can appeal the Board of Adjustment decision to Superior Court. In other words, the governing body, the county commissioners in our case. All right, getting back to the parameters of quasi judicial decisions. So appearance of any official new issues. If the official who made the decision must attend the hearing as a witness, this is more for appeals, but obviously if I deny somebody's permit, I've got to be here to explain to you guys why I denied that permit during the appeals process. The appellant is not limited to matters stated in the notice of the appeal. And if new matters would unduly prejudice any party, the board shall vote to continue the hearing at a later date. Oaths, this is pretty self-explanatory. You guys have been great about this. Anybody presenting evidence, staff included, must be sworn in prior to the conduct of the hearing. And then subpoenas, the board through the chair or anyone acting as chair may subpoena witnesses as an evidence. So a good example might be during the last variance hearing, we had that email from the fire marshal's office. It would have been completely appropriate for the board to say, this email is not good enough. We want to subpoena a representative from the fire marshal's office to be here to speak on this matter as we conduct the hearing.
Actually, I think there was some discussion about that.
Right.
With Lawson Brown.
Right.
And I kept saying I wasn't gonna run my mouth, but I think I actually touched base with you before the meeting about that.
Yeah.
About where to, and particularly what I was questioning there was, with it being, an email that was created in the county by a county staff, the fire marshal, then I personally felt like that was legal. You know, it wasn't some outside.
It didn't go from
Influence.
Chapel Hill.
That's right. It didn't come from somebody else. So, and I had actually touched base with Matthew about that before the meeting because I was ready to make a ruling on that if it come up.
Yeah.
That I thought it was allowable, you know, that it was created from the county.
Yeah. So with regards to subpoenas, this procedure appears elsewhere as well, but chair's decision regarding subpoenas may be immediately appealed to the full board. So let's say under that circumstance, they wanted to, a party wanted to make sure that the fire marshal was here. And you said, no, I don't think that's appropriate. That could immediately be appealed to the full board, and then the full board votes on that, whether or not to allow it. In that specific instance too, I don't think you don't need a 4/5. You need a simple majority within the context of, working through the variance case. Appeals in the nature of certiorari, this is a lot of legal stuff that typically deals with certificates of appropriateness in the scope of quasi judicial review. I don't think I'm qualified to really get too much into it. When Michelle's here, maybe she can give. Voting, so a 4/5 supermajority, if you will, is required to grant a variance, but a simple majority is required for everything else. So if it's an appeal, if it's a certificate of appropriateness, a special use permit, anything like that, all you need is a simple majority. You only need a 4/5 in the case of a variance. And the same goes too for just minor procedural issues like amending your rules of procedure, simple majority. You don't need a 4/5 there. Okay, decisions. We've talked about this quite a bit. The board shall determine facts and make decision within a reasonable time, which is rather vague when it comes to the general statute. We've now buttoned it up to make sure that we're gonna get that out the door a month later. In appeals, the board may reverse or affirm wholly or partly and may modify the decision being appealed. Any such decision shall be published in writing and then transmitted to the applicant and property owner. So that middle sentence there, we've not dealt with an appeal yet, but imagine that we do, and there are 5 aspects of the denial that we issue for an applicant. And you guys stand by 4 out of 5 of them, right? But only the one remains. You can chart that path. You can say just this one specific aspect we're going to approve or deny. This is very important too, and I know that this is something we've covered, and as far as I know, you guys are great about abiding by, but it regards ex parte communication. In other words, communicating about the case prior to the hearing. So General Statute 160D-109D gives you instruction here. A member of any board exercising quasi judicial function pursuant to this chapter shall not participate in or vote on any quasi judicial matter in a manner that would violate affected person's constitutional rights to an impartial decision maker. Impermissible violations of due process include, but are not limited to, a member having a fixed opinion prior to hearing the matter that is not susceptible to change, undisclosed ex parte communication. In other words, you guys get together at the diner and talk about how you're going to vote before the actual hearing takes place, before the evidence is presented. If you have a close familial, business, or other associational relationship, which might affect your decision, or if you have a financial interest in the outcome of the matter. Those are the primary situations. Again, it's included but not limited to those situations. That's why the chairman asks prior to engaging in these decisions if you have any conflicts or any other matters that may preclude you from participating in the hearing. Any questions on any of that so far? And this next one is a little bit of a summary. So as we went through those, you can kind of break it down into 3 different silos: before the hearing, during the hearing, and then after the hearing. Before the hearing, the meeting notices go out, the sign is posted at the property, the administrative materials are all kind of packaged up in one bundle and distributed to the board. And then no ex parte communication. Don't talk about the hearing at all, and avoid those conflicts of interest. Don't talk about the hearing until the hearing actually happens.
Let me interject something here what I got on my
Yep.
mind. Now, it was entirely appropriate for Mike over the last variance request, you had gone out and looked at the property.
I was getting ready to ask
There's
a question about that.
absolutely nothing wrong with that whatsoever.
Right.
It would be a problem had you stopped and talked to Mr. Prevet.
That was my
And
question.
he
What
tried,
if he come out there, I introduce myself, I'm on his property, he don't know me. I say, okay, I'm with the Board of Adjustment.
Right.
I just wanted to see
and I
with my own
can't
eyes
discuss it with you.
what where is the line at?
You need to
Yeah.
draw the line and say, Mr. Brevet, I'm sorry, I can't discuss anything with you. I just wanted to see this with my own eyes. You're welcome when you come before us to say anything you want to. But I'm required by law not to talk.
That
to
was
you.
my question, where,
Yeah,
you know,
we're-
where
We're required by law.
stop being polite and breaking the law.
Yeah, yeah. In my opinion.
Well, and that's,
Yeah.
You know.
Well, it's an excellent, I mean, it's a really, really excellent question. And honestly, too, I would say that folks in rural counties and small towns have an even higher burden maybe, or a little bit
Because
more
they
of
know
a
everybody.
problem with that, because you know so many people
Yeah.
in the community, right?
Yeah.
You see them at the grocery store, you go to church together, whatever.
That's right.
You may have gone to high school with them years and years ago. You know, if you live in Charlotte or something like that, you're gonna have people before you never met them.
But you know, even to pick up on that even more, you know, if Ray was to say, well, you know, I believe Mr. Prevet's got a real problem down there. Well, the way I would handle it, I say, whoa, Ray, we can't be talking about that. We'll have to wait and talk about that when we have our meeting. You know, that's the way, and you've got a good out because the law supports you in saying, no, I can't talk to you about it. I'm sorry, but you can certainly come before us, appear before us, and that's your right. And then, you know, so I think that's an important thing
Yeah.
because somebody might someday, you know.
well, you know, had that happened, he'd come out there and talk to me.
Yeah, that's right.
I've been asking him questions.
Hey,
Well, what are you gonna do when you do this?
Yeah, and
If we do this, what's going, you know,
that would be
trying to get
improper.
a feel for the whole
That
thing,
would be improper.
and that, you know, and I'd be doing it out of stupidity because I didn't know no
That'd
better.
be improper.
What's the old adage? You don't write anything down. You don't want to end up on the front page of the newspaper.
I've stated a lot of times, this thing is almost like a court of law.
Mm.
You know, you've really got to, we're supposed to base our opinions on what's presented to us, you know, by the person that's requesting a variance. Like Mr. Brown, it was his job to present Mr. Brevet's position to us, and if we had questions, then that's when we question them, you know.
But in this context, I would ask yourself, what are the ramifications if my conversation or my conduct gets appealed and becomes subject to Superior Court?
Yeah. Yeah.
And I have to ask myself that. a
Well,
lot.
you know, let's take it another step further. If I was sitting in the chair and when I polled everybody, if you told me, said, well, yeah, I had talked to Mr. Prevet out there. This is probably the way I'd handle it. I don't know, but I would probably say, well, Mike, you know, there could be a potential conflict there could come up, and I'm gonna ask you to step off for this particular variance. That's probably the way I would handle it.
Matthew, can I throw in an opinion?
Yeah.
You rode by and looked at the project.
Mhm.
Did you have a conversation with the man?
No.
He's done no wrong.
That's right.
The thing is I understand you can see it on paper.
Mhm.
You can have some nice pretty plat in here. You can have it up there on the wall. When you lay your eyes on it, just like what Mr. Wilson did, he's familiar with what's happening.
Mhm.
He's got an idea when it comes time for testimony, evidence, all this other stuff. He's got a good full understanding of it.
I agree.
Well, in that
100%.
particular case, what they was asking the variance for, I didn't see a problem with that, but I saw another area that I thought was a problem, but it wasn't part of the variance, so I never brought it up.
That's right. Wasn't involved. None of our business.
Just keep in mind, like you said, this board and the seat on this board is a lot of responsibility that we did not have to deal with on the planning board.
Yeah. Oh, yeah.
So
A lot of rules to remember.
Yeah,
You
that's
gotta
the
be
big
like a
deal.
referee.
That's why I say, read that book. Familiarize yourself with it. Cause it explains a lot. It gets pretty technical.
It
Matthew,
does. Yeah,
how far in are we?
we're getting close.
Go ahead.
All right, so let's see, did I skip ahead? I did. All right, so during the hearing, you administer oaths first before you do anything else. You have evidence presented, and you may have new evidence presented. In those situations, it's ruled on by the chair and may be appealed to the board if necessary. And then again, with regards to voting, 4/5 is required for a variance, but a simple majority is required for everything else. After the hearing, the decision is made within a reasonable time. It is reduced to writing and delivered to the applicant and any others withstanding. And then all decisions may be appealed to Superior Court. Big one to keep in mind. Appeals. Who may appeal? This is governed by North Carolina General Statute 160D-405. So who may appeal? Anyone with standing, and we went over who qualifies for having standing. When may they appeal? That would be within 30 days from receipt of the written notice. So in other words, if we denied a permit 3 years ago, their window of opportunity has closed. They've got to appeal within 30 days. What is the record? You guys have dealt with this a lot now. The record is the official, or as the statute defines it, the official who made the decision shall transmit all related documents to the board, the appellants, and any property owner if different. That constitutes the record. How does the process unfold? Again, that's a quasi judicial hearing that we've talked about. Enforcement of any fines are stayed if those are involved in the process. In other words, somebody's in violation of the ordinance and we're hitting them with a regular fine, that is put on hold until the appeal can be adjudicated. And then alternative resolutions may be reached in accordance with 160D-405G. Where is the appeal conducted? Again, that's before the Board of Adjustment. Variances, I'm not going to read all these because you guys are familiar with them, but this is taken directly from general statute and we go over this before every variance case. These are the 4 main criteria that you have to look at before you rule on the variance. And you guys do an excellent job of making a decision on each of the cases and each of the criteria, not just taking them all as one
I
blanket.
want to pick up on that for Ray's benefit with this. Now, according to the attorney, county attorney, he says he thinks it's sufficient if we vote. We don't have to break it down individually. I disagreed with that. Matthew and I had a discussion about this last year. As long as I'm chair, we're gonna vote on each one of them individually, because that way I'm convinced that everybody understands better how we're coming to that decision.
It may be a little bit more thorough.
Yeah, that's right.
Yeah.
So that's just
Mhm.
food for thought.
Yeah, and maybe we'll get into this a little bit later on too, but I had a really good conversation with Michelle after our last variance, and just with regards to the format of the presentation of evidence. So I think what the attorney presented was perfectly fine, but to your point, probably would have been better if that was submitted ahead of time. And the format in which he submitted that, we as staff probably need to be doing that as well, so that you guys can almost do a side-by-side comparison of the contested facts. And, you know, what I imagine that's going to look like is on our part, we'll say, this section of the ordinance says X, Y, Z. This applicant submitted this application on this date. It was noted that this portion of the application is insufficient with regards to that section of the ordinance, just a real standard statement of facts. Then they're going to have their presentation of those contested facts as well. And that will more succinctly make up kind of a side-by-side comparison to construct the record. And that, from what she said, is more the format that a Superior Court judge would be looking for if it's ever appealed.
That makes sense.
So something to think about.
Yeah, that makes sense.
I just thought that might be worth noting. If and when we have another variance and you see that things are in a little bit different format, that would be why. We went over, that's the same thing with regards to variances. Other important things to remember about variances, you cannot approve a change of use by variance. So this applies really more to zoning cases. Somebody says, hey, I've got a particular hardship here. I want to become a hardware store. And the ordinance just doesn't allow for hardware stores in that district. You can't automatically just change zoning through a variance. Conditions, any conditions that are imposed on the property must be reasonably related to the variance. And then the variance may be requested from any county land use regulation. So this would be flood zone, watershed, RV parks, subdivisions, it doesn't matter. The variance is applicable to any provision of this ordinance. Okay. So we're done with the educational portion of the presentation. We've gone over the types of decisions, the regulatory authority, conducting a hearing, appeals and variances. We're about to get into the mock trials.
Stuff.
Do you guys have any questions about anything we've covered so far before we get into the practice hearings? I know that's probably a big question because we covered a lot.
I need to ask you for a quick favor.
Yeah.
Can we have a 3-minute recess long enough for me to run to the men? There.
Absolutely.
Just give me a few. It is killing me.
Sure thing.
Just general discussion. When those are 4 items, one of them of which is, does it create a hardship? That's the personal interpretation of the facts, isn't it?
Certainly. Certainly.
And so that's,
That gives you a
it
little
just
leeway.
seems like it's out of place
Yeah.
to put that,
It gives you some leeway.
Item
that
number one
point of-
there, unnecessary hardship would result in the strict application of the regulation. I think you're exactly right. And I'll go back to a portion of state law that I think is worth repeating. Let's see here where. Okay. A quasi judicial decision, a decision involving the findings of fact regarding a specific application of the development regulation, and that requires the exercise of discretion when applying the standards of the regulation. So you're exactly right. I mean, I think you've identified a really interesting gray area as you work through this type.
and I
of
think they put that in there intentionally
Give us some
to-
leeway.
to let somebody use some common sense instead of
Right,
what the Philadelphia wrote, I
Yeah,
mean, the lawyers wrote.
yeah.
yeah, I agree 100%.
And you're exactly right. I mean, when it comes to a hardship, person A might look at something and say, hey, look, I mean, you're only talking about $5,000 for this, for the total cost of this
Mhm.
project. And person B is gonna go, man, if I had to pay that $5,000, I'd just quit and go home.
Yeah.
So you have to exercise discretion there. Yeah, I think you're exactly right. That's an excellent point.
Thank you.
Yes, sir.
Hey, remember, he's working for us up here. So you can say, I'm gonna have to pause here for a minute. We can take a 5-minute recess. You don't have to ask Matt.
I know, but I want to be polite about it.
All right, so again, we're kind of at a logical break in the presentation, gonna move on to the variance and appeals.
I do have a question.
Yes, sir.
On, when going through the, and, we have a meeting and we can't come to a decision. And we, then throw it forward to the next meeting or a special call meeting, or, and then when is that decision? Then becomes final after, so it could take out
Yeah.
more than 30 days.
Sure,
right?
yeah. No, I think if you had a hearing tonight and evidence was presented and you're involved in a really good, deep discussion and you're contesting facts and kind of going back and forth and it gets to be, 9, 10 o'clock and you say, I don't know if I'm ready to make a decision on this. So I think we need to take more
Make a
time.
motion to table.
Make a motion to just continue to the August meeting.
Yeah.
Dispense with it then. I think that's
I
perfectly
believe
fine.
in our handbook, it's at the discretion of the chairman.
Yeah,
And that's when the special meeting come up. Maybe we'd have one the next week rather
Right.
than next month,
Yeah.
you know.
you could do
I
that.
believe that's the discretion to the chairman.
But no, that's a great question. And again, I mean, it's perfectly fine. You got to imagine in other jurisdictions, these hearings do take multiple meetings.
And I want to say this to everybody. There's no, as long as I'm sitting in this position, let me tell you, there's no such thing as a foolish question if you don't know the answer to it. That's what we're here for. So ask the people, I mean, that's what we're here for. And I mean, and I'll also say, don't let it come to a vote until you're comfortable in your mind of how you're coming to that decision. That's the reason that we need to explain on those 4 questions, what our reasoning is for the way we're gonna vote on, what the motion is. We're not, and it's just not saying, I make a motion that we deny this, or I make a motion we approve this. You need to say why you're making that motion, based on what facts. And that can be a little tough, But
The
it's
question I would have had, sitting out there on that, approval y'all had was, didn't have, privy to that information, but what that drive was made out of. I mean, was it just grass growing over the tree root?
Another thing that's important that I
I
started,
could ask that question at some point.
I started to bring up, I'm gonna address that.
Okay.
I started to bring this up a little bit ago. It's important for us to remember that they have already made a determination. The county has already made a determination that everything is okay except some specific problem. So it would really be improper to say, well, or if Mike, let's use Mike for an example. He said, well, this thing ain't got enough gravel out here. That's not about our decision. That's not what we were here for. We weren't here to decide whether it's enough gravel or not. We was here to decide just about that 25-foot variance request. So that's something that may come up in one of these things tonight. It's just, we are supposed to be focused on what's presented to us and not the overall deal, because the county is supposed to have already signed off on that. Isn't that right, Matthew?
Right.
Are we good?
Okay.
Yeah, ask anything else. That's what we're here for.
Oh, yeah.
That's fine. I mean, I just didn't know if we could ask more than. My thought was during that procedure was, okay, Mike was complaining about running over tree roots and this and that and the other. And I mean, was it something was there a hard road being put in or anything like
Sure.
that? That would have maybe persuaded me one way or the other, or if it's just a mud path running through there, you know what I mean?
No, I think that's perfectly appropriate.
Yeah, it is.
Anything related to the case, and, a lot of, variance hearings that I've seen, board members will ask about alternates to the proposed plan. They'll say, well, look, you got 5 acres here, but you're proposing to kind of build in this corner. What's to stop you from, why didn't you just put this whole development in another?
During that procedure, if I'm not mistaken.
Sure.
We did ask about that.
Anything and everything. I mean, I would explore it down to every detail to your heart's content. Yeah.
Yeah, that's the point.
Okay.
Is that there's no such thing as a bad question if you don't know the answer.
Right.
But having said that, it needs to be an appropriate application, a question. But because we're supposed to be focused on a specific request. It ain't our job to do the county's job. They're supposed to be the ones that signed off.
Yeah.
And I think Matthew made the statement last time that it had passed, I think it was actually in our package, that everything met, and I think Matthew stated at the meeting, that everything met the criteria except that 25-foot variance.
Right. Yeah,
So-
anything that's reasonably related, like during the last meeting, if somebody had said, well, how much you plan on charging people a night to stay at your RV park?
That'd be
That's
it.
totally
Inappropriate.
out of the scope of the issue at hand, right? Or, how much is an RV running somebody these days or something like that? Or even too, and I think that, it's natural and normal for a lot of folks in local government to get tripped up on potential economic or tax benefit to the county. Right? To say, man, if this is approved, look at all this tax revenue that could flow into the county coffers.
It's the wrong board sitting up here.
You are technically supposed to completely disregard that whatsoever.
They break the rules every time they sit down up here.
That's a different board.
That's a fact.
But they make legislative decisions. That it is appropriate for them to think about economic development and tax issues.
That's not our place.
That's not your place. You think about quasi judicial decisions.
We got to decide
I'm good.
on what's presented to
Yeah,
us.
that's right.
Yeah. All right, you ready, Mr.
Yeah.
Chairman?
Sure. At this point, I need to swear in all the people that will be participating tonight.
That's right. I'm gonna play the role of Matthew Hoagland and John Belchner,
Okay.
I think is applicant.
All right. That's okay. I'll be glad to administer. Everybody stand and raise your right hand. I, please state your name.
I, Matthew Hoagland,
Do solemnly swear or affirm that the evidence you so give to the board in this action shall be the truth, the whole truth, and nothing but the truth. Nothing but the truth, so help you God.
I do.
Do we hear anything out of Mr. Belcher?
Mr. Belcher does as well.
Thank you.
Thank you.
Okay. Matthew, you please present what you have for the board, please.
Yes, sir. Thank you, Mr. Chairman. The Belcher family is requesting a variance from Article 6, Section 6.1.1 of the Alamance County Unified Development Ordinance, which among other things requires a 30-foot front setback for all buildings along public roads, and that's a setback from the public right of way. The documentation, by the way, for this variance case is in this. This is the appeal, which we will get to later, but right now, this is the focus. Their proposed home addition would encroach 5 feet and 1 inch into that 30-foot setback. The front of the home is currently exactly 30 feet from the right of way, which is the county's minimum standard. And this layout is detailed on the engineer drawing in your packet, which is labeled S1 in the agenda packet. So this is the detailed measurement that's in your agenda packet. You got some other additional documentation and photos in there as well. The Belchners are requesting this variance because they feel it is difficult to accomplish various tasks based on the current layout of the entrance of their residence. These tasks include bringing groceries and furniture into the house, as well as welcoming guests when they arrive. In their request, the Belchners have stated that they have resorted to driving over the lawn to access the back entrance of their house, and they feel that this home addition to the front would also improve the house's curb appeal and increase tax value for the county. As you deliberate, please consider each of the following variance criteria. And I'll just put these back up on the board here. We've repeated these many, many times as we've gotten together. And please remember that 4/5 vote is required to grant a variance. And for the record, please address each of the criteria individually as you deliberate and vote. And with that, Mr. Chairman, I'll be happy to answer any questions you might have before you hear from the applicant.
Matthew, what's the county's position on that front setback?
So the ordinance specifically states that the front setback is 30 feet from the public right of way. The Belchners live along the public right of way, and that's a uniform standard that we enforce countywide for those types of roads. We cannot administratively approve a violation of that setback standard. That is something that would have to go before the Board of Adjustment. And that's why the variance case is before you tonight.
Okay, so simple question. I'm assuming this addition they were discussing or planning to do would be encroaching on that 30-foot mark.
I'm sorry, I didn't understand your question.
So the proposed addition that these folks are talking about, would it actually encroach on that 30 feet
Yes,
setback requirement?
it would encroach 5 feet and 1 inch into that setback. So their new distance from their house to the right of way would be 24 feet, 11 inches.
Mr. Chair,
Yes, sir.
can I tell you, I believe I got a conflict here. I know these people. I live in the neighborhood. And I realize that, I'm needed tonight because our other alternate's not here. So, I'm sorry, but I don't feel comfortable sitting here. So I'm sorry. So now you've got to make a decision. I'm just helping. You got to make a decision. I don't believe you can go forward. Because you're only gonna have a 4-member board.
We need a 5-member board to have a 4/5 vote.
Ain't but one of me.
So you can't go forward.
Okay, so, Mr. Pope,
You can, but it had to be unanimous then.
Exactly.
okay, so
Or to constitute a quorum.
that's right.
So you
So
still have a quorum to conduct business.
I understand that.
So now I'm gonna back away. Okay,
But the
I'm gonna
math-
be back on here now. I was just throwing that monkey wrench in there.
The way the math works out is if you ever have one absent and it's only down to 4, it has to be a unanimous vote. Because 3/4 is shy of 4/5.
Understandable.
Can I ask a question?
Sure.
Which is why,
Can you poll all the members and ask what they want to do?
I think that's a great idea.
and if anybody's got a conflict.
Mr. Wilson, do you have conflict, sir?
I do not.
Thank you. Mr. Holt, do you have a conflict?
No,
Ms. Hatter, do you have a conflict?
No, sir.
Mr. Poe, do you have a conflict?
No, sir.
Okay. I do not have a conflict either. So there you go.
We work this,
same ones first.
yeah,
I think it's important
that's
that,
good.
that, to always remember to poll it, to
Mhm.
get that on the record.
That's a good idea. Mr. Hoagland, you presented everything you have on your side.
Yes, sir. That's all the information I have in the staff report. If you have any other questions about the ordinance or the particulars of, the application, I'm happy to answer.
Anybody have questions for Mr. Hoagland?
This picture here, figure 2,
Mhm.
how is it important?
Yeah, so these
How
are
is it
photos,
relative? How is it relative?
yeah, so these are photos that the Belschners, presented. And again, Mr. Belschner is here without the glasses to answer questions as well. But these are just photos that they presented, in their application as, from what I understand, is their demonstration of their hardship as to why they feel that this home addition is needed. As I mentioned in the briefing, the Belsters mentioned on their application that it is difficult to accomplish various tasks with the current entrance of the house, like bringing in groceries or furniture, as well as welcoming guests when they arrive. And so I think they included that photo because they have a particularly narrow opening there when they open the door in their current front entrance.
Thank you, Mr. Belcher.
Mr. Hoagland, if you presented everything you have, maybe it's time for us to speak to Mr. and Ms. Belcher.
Okay. Mr. Belschner here. So thank you, Mr. Chairman. I appreciate you guys having us tonight and hearing our case. And yeah, so as Mr. Hoagland mentioned, we're applying for what we think is just a minor encroachment into the right of way. We want to build on an addition to the front of our house. It's only going to be about 5 feet. As it is right now, whenever we bring groceries into the house and furniture and we have guests over, we've got a really cramped front entrance there that's hard to navigate. One thing too that I want to mention is, a lot of times we can't come through that front entrance based on the layout. So we've got to drive around to the back of the property. Well, the back of the property is a little bit hilly. Whenever it rains, we've got ruts in the grass and tearing up the yard. And my wife, we're both getting a little bit older. My wife's knees aren't that great. And so she has trouble getting out of the car in the back of the house to get in the back entrance. And especially whenever she has an armload of groceries. So I see this as really a safety issue as well. Our health and safety as we get older. We're lifelong county residents. We want to retire here. We want to live here until we die and leave this property to our children. And so, I don't think it's going to be that much of an encroachment into the rules. I think it's going to increase the value of the house and the curb appeal of the house. And I think it's also a health and safety issue for my wife and I as we retire and as we get older. And I also want to make sure that I show you this rendering that our contractor put together in the back of our application packet. So the top image is what our house looks like currently. And then the bottom image is what it would look like after the renovation. And I think you would agree, this is much better curb appeal. It's going to increase the tax value of the house, make it better for us from a health and safety perspective, and then just be overall a positive contribution to the neighborhood. I'll also say that, we live in a neighborhood with some older houses. Our next door neighbor, his house was built, I think in the 70s. He's only about 10 feet from the sidewalk. He's already up there encroaching in the setback. And then our other neighbor over here, I think he's only about 20 feet from the right of way. So even if we build this, we're still not even going to be as close as they are. So I appreciate you guys hearing what we have to say on this issue, and I would just strongly encourage you to approve this for us.
Thank you, sir.
Yes, sir.
Ms. Belcher?
I stand by what my husband said.
Smart one.
Okay. Let's open this up for discussion amongst ourselves.
For questions.
Yes. Let's open it up for questions. Anybody have questions for Mr. Belcher?
I do. Mr. Belcher, I'm not sure I understand exactly your position about, a drive around to the back. Are you not able to gravel that area? Would it not be possible for you to gravel that area and to create a drive?
Yeah, well, we've thought about graveling it and we've thought about paving it. And, when we've talked to contractors, the cost to do gravel back there and maybe do a back entrance is about the same as the cost to do this front entrance. So it's kind of 6 of one, half a dozen of the other, if we were to go that route. And again, we already use the front entrance. Our neighbors and our family know to come in and out of there. It's a lot easier to bring in the groceries and furniture and other things that we need to. So we've explored that. Just from a cost perspective, it doesn't make sense for us to do that versus just go ahead and put an addition on the house in the front.
Matthew,
Yes, sir.
is there anything that the county would, object to him putting another drive into the back of his house?
No, sir. We don't have any issue with, them putting a drive into the back of the house. And even if they did want to put a similar entrance onto the back of the house, it would not violate the side or the rear setback. So that would be approvable under our current rules.
Mr. Belcher,
Yes, sir.
how long have you and your wife lived at this location?
We got married in 1984 and then we moved in 1985.
So we're gonna say pushing 40 years. Does that sound about right?
That's close.
All right, so you've been living here for 40 years
Yes, sir.
and you just now have a problem getting in the front door.
Well, it's been an issue for a while. We just now got to the point where we saved up some money. I mean, obviously this is gonna cost us a little bit, but we've been kind of thinking about it for years, saved up some money and decided to just go ahead and move forward with it here recently.
Mr. Belcher, cosmetically speaking, I'm not sure that is something that we need to take into consideration on this board. I agree with you. It looks nice. But, the tax value is not an issue for this board to take into consideration, I'm afraid. So I hope you'll understand.
Mr. Belcher, you have any evidence that the next door properties are closer than, because according to what I'm looking here at this plat, you're on a corner lot, one. And I don't see anybody to the left of it. And then it looks like the existing dwelling is not within an encroachment area to your right. Do you have any evidence that would prove otherwise? To that statement?
I do not. I kind of just made that up off the cuff when I was talking earlier. But no, I don't know about that measurement on your page there. But, I'm pretty sure when I go out my front door and look to the left, that my neighbor is closer to the street than I am.
Mr. Belcher, I've got a question for you.
Yes, sir.
Do you have any disabilities or physical limitations prevent you from getting in and out of this house?
We don't have any diagnosed disabilities. But like I said, we are getting older. My wife's having some issues with her knees. I'm having some trouble with my hips. I think it's just a matter of time until, we might need a little bit of assistance or wheelchair access or something like that. I mean, as of right now, thankfully, we're healthy. But as I mentioned, we do plan to retire and stay in this home for the rest of our lives. And those types of issues will probably be something we have to face in the years to come.
So while, sir.
Yeah.
While it looks like, your existing, the setback is measured from the actual foundation of the structure. And that your existing front stoop is already encroaching on the 30 feet. Is that correct?
Yeah, I think technically that's what that,
Okay.
the document labeled S1. I think technically that's what that shows.
Okay. So if, that,
Well, actually, no, the walkway is just a paved flat surface. The entryway begins at that primary foundation wall.
where's the 30-foot measure from? Just, right.
Measured from the corner of the house. If you look at the document labeled S1, measured from the corner of the house to the front, right of way.
All right, so the existing stoop then would be already encroaching that 30-foot.
Correct, but from what I understand from county regulations, they measure, the vertical construction. They don't measure paved areas or driveways or anything like that, so.
Okay.
Mr. Pastor, and I have to ask this question. Do you have, public water sewer? Do you own well and septic?
We do. We've got public water and sewer out there.
So you could come up the backside of your property with a driveway and put a service elevator in the back of your house.
I think technically we could, but I think a service elevator is gonna cost us a lot more than a front entry on our house. I mean, when we talk to contractors about gravel or paving or doing some type of a back entrance, the cost was the same or more than just doing this front entrance. So we haven't even entertained the idea of an elevator there. I would imagine that would be extremely cost prohibitive.
So from my perspective, sir, is that rendering, that shows the front wall basically relocating out front of this stoop, because you're gonna enclose the stoop and add another little stoop to it. That could, if that's not gonna constitute, any vertical construction as county setback, you could actually just add that maybe additional stoop area and additional sidewalk and come more directly into the house rather than coming up the steps that are, parallel to the house, right? That be, Mr. Hogan?
I think that, yeah.
Would that be a problem for?
Yeah, that was what I meant.
Yeah.
Well, does anybody have any further questions?
Yeah, I got a question for the county.
Yes, sir.
Isn't there some, or there used to be, because I run into this when I was building, isn't there some segment of the ordinance, or it used to be, or if it could be grandfathered in, if you have adjacent residences that are closer to the right of way than the current regulations, then you would be allowed to be closer. I don't know what section that is,
Yeah,
but I ran into that to a house I was building one time,
yeah.
and they wanted me to set it way back. And I found this part of the regulation that said if neighboring houses were closer to the road than you were, you could come as far as they came.
Yeah.
Is that something that's in the,
So that is not part of the current ordinance, but it's actually really funny that you mentioned that, because I got a call from Sean Tenser, the town manager of Haw River yesterday. We were talking about all kinds of issues. And he talked to me about how when he worked in Greensboro, they had something called the prevailing setback.
I had it in the city of Burlington. I
Okay.
don't.
So, and I really wasn't even aware of that, but I think it's a good idea, but it's not currently in the ordinance. But the prevailing setback would be exactly what you said. Let's say the measurement needs to be 30 feet, but your neighbors are 10 and 15, then you could come up into that 10 to 15 range because the prevailing existing setback of the existing structures already provided that kind of dynamic.
And I've got a variance
Yeah.
right now in the city of Graham where I cleared a lot and was gonna build a house, and it was the last house on a street, dead end street, not a cul-de-sac, dead end street. The city of Graham had increased the road right away because it was adjacent to I-40, thinking someday they may build an exit ramp there And instead of having a 40-foot road right of way or a 60-foot right of way, they had an 80-foot right of way, which put me having to build a house in a gully.
Mm,
I was able to get a variance for that.
Yeah.
So,
And,
so to get back to Mike's, point, currently, the county does not recognize. So,
County doesn't have any flexibility in that front setback.
So I'm gonna ask you a question. I just thought about this.
Yes, sir.
This 30-foot setback from the front, is that from a restrictive covenant? Is that from a county
That's
issue?
county regulation.
That's county regulation.
Yeah, restrictive covenants that are local to a neighborhood can be more restrictive, but they can't be less restrictive. So they can't allow for a violation of the county's rules. The restrictive covenants that could say you have to be 50, but they can't say you can be 25. But the county standard is 30.
I understand. So if you got two neighboring houses that's much rather close to the roadway, and this house is back at 30, was this 30-foot, was it adopted before or after the construction of this house?
It was probably adopted after the construction of the house.
so does the county have a grandfather clause?
The county does have grandfathering and non-conforming provisions for properties that are non-conforming. But this property isn't non-conforming. It currently conforms to the 30-foot setback regulation. We can't administratively approve anything that creates a new non-conformity.
Gotcha.
Mr. Belcher,
Yes, sir.
was your house built before or after your neighbors?
Our house was built after our neighbors. Their house was built in the 1950s, I believe, and ours was built in the 1970s.
I was thinking more like 1960s, but anyway.
Yeah. Meet in the middle.
Foot level says 70s.
I'm curious about something. What
Yes,
did they
ma'am.
do with that 3 inches right there? What is that?
That's where the door stops in the first step going
That's
upstairs.
the measurement
What is
between,
that little, it's real,
It's tiny. Well, I doubt they're gonna carry the groceries upstairs.
uh,
But,
that's between the door and the steps.
so Mr. Chairman, are we
The
ready
door in the
for
bottom of the
enter
steps.
discussion now? Or are we still questioning?
If no more questions is from Mr. Belcher or Mr. Hoagland or Miss Belcher, even though she's being real quiet, then we need to go ahead and get on with our discussions.
So that part of the, variant is over.
That part of discussion's over. It's time for us to do our thing now.
Okay. So, I fail to see where, there's some hardship involved. But, it comes down to one of the 4 questions. Is it a hardship that the owner brought on himself? You know,
Yeah, my feeling is that, okay, the picture of the 3 inches doesn't have anything to do with it. That's just a design issue that they're not helping with. I mean, if
yeah, that's not for this board,
that's not for this one.
in my opinion.
just the.
Yeah.
I understand.
But he included in like it was gonna be some kind of issue. Okay, but I would tell him that,
Does it actually look like that now?
No, the top
I don't
picture.
know. I think this was from a variance case in like Indiana or,
Top picture is, that's the
Or
somewhere,
somewhere.
his contractor's rendering of how it could look with the addition.
Oh, okay.
yeah, this is not a property in the county. This is somewhere out of
If
state.
I understand our job is not to decide about cosmetics at all. Our job is not to really to decide about, tax values, where it increases the tax value.
Oh, yeah.
I don't think that's our job, is it?
No, sir. Well, my thoughts on the whole thing, they bought the house back in the early 80s. Obviously, they was considerably younger. I mean, they walked through the house. They didn't just buy it sight unseen. Okay? So as far as front door opening right there at that bottom step going upstairs, I mean, that would have been obvious the day that they first viewed the house.
That's been a problem a long time, right?
Well, it has. So I understand we get older. I mean, obviously she's having knee problems. I mean, I feel her pain. But
And so if I understand right, Mr. Belcher is bringing that up, as a potential hardship for them as they get older. Maybe it hasn't been up until now. I'm not saying that would make me vote one way or the other, but, you know, that's the way he's looking at it, I suppose.
well, is there any further discussion?
Let's see. These setbacks, I want to make sure I understand. The county would allow him to increase the size of the stoop as long as he didn't build any walls or put a roof over it. That's okay with the county?
Yeah. It's like your driveway. Everybody's driveway encroaches in their setback.
Yeah, yeah.
Right? We just don't enforce setbacks on horizontal structures on the ground, only vertical construction.
I went back and I pulled up the GPS on this. And I see that the subdivision, looks to me like it's a pretty old subdivision. You know, granted, it looks like the other houses may be a little closer to the road already. But I agree with what my cohort says here. Mr. Poe, I believe that it's, and Sharon also, I believe that it does, you know, he's got ways he can get to the back door without any problem. And I think one of the issues for this board is to think about precedents, you know, or, you know, if we allow this guy to, just because he's getting some age on him and, you know, he has a way to remedy his problem. You know, it's not like it's a hardship that can't be handled. He's got a way to remedy the problem. So I personally, I have a problem granting him a variance because he's got a way that he can get to the back of his house without a problem.
Or improve the front.
And the front door situation, I think is beyond our consideration. You know, if he couldn't go in the back door, then that would present an undue hardship, I believe. But because he has access to get in the back, I don't buy, I sympathize with, and I see that's a problem. But I don't believe that I could vote in favor of a variance because he has a means of getting into the back of his house. I would not want to see this board set a precedent of allowing somebody to have a variance when they've got a way that they can correct the problem. And I would remind my fellow members on the board, it's not our job to take into consideration financial considerations of what it would cost to do it. That's not our job. That's sort of my feeling.
Be with you, because they could go around and it would be easier to fix that. And it wouldn't be a whole lot of money.
Understandable. My only concern is there's other houses in that subdivision that are clearly closer than 30 feet. So I'm understanding everybody, but you know, if the other houses were constructed and the county came up with a 30-foot setback, I understand that too.
Mr. Chairman, I believe we're gonna open up a can of worms for the county if we start letting people have a variance because their neighbor's house is a little bit close, you know.
I understand.
falls in.
Take a look at number 2, the criteria as well. Second sentence. Hardships resulting from personal circumstances as well as hardships resulting from conditions that are common to the neighborhood or to the general public may not be the basis for granting a variance. So just because it's
because his neighbors is that away.
Right, just because his neighbors are encroaching and non-conforming doesn't pertain to this particular development on this property.
Mr. Chairman, I believe it's time, for you to address each question for us.
All right, folks. Our question number one, vote number one. Is there an unnecessary hardship that would result from the strict application of the regulation? Is it not necessary to demonstrate that in the absence of the ordinance, no reasonable use can be made of this property?
I'll make a motion that it is, that it does not present an unnecessary.
I'll second that.
Okay, we have a motion and a second. All those,
And as you deliver it again, so
Why?
we need a statement of finding of
Why?
fact
And,
corresponding to each criteria.
and the reason is,
So the
Okay.
facts of the case lead you to believe that because.
I'm with you.
my motion, the purpose of my motion is to say that he has another way that he can get into his house without having to have a variance.
Understandable. All those in favor signify aye.
Aye.
Opposed, no.
No.
Before you do that, though, you always will ask about discussion, any further discussion
Any further discussion on this issue?
before we vote. Move on. to
Okay,
number two.
well,
Move on to number two.
all right.
Did you vote?
I did not vote.
You need to vote.
It's got to be,
4/5.
Yeah.
I'm gonna vote in favor of the
In
motion.
favor of his motion to
Yeah.
deny.
Correct.
So the denial is 4/5. The
Gotcha.
approval is 1/5.
All right, so that
On
brings us,
item one.
to item two.
Mhm.
The hardship results from conditions that are peculiar to the property such as location, size, or topography. Hardships resulting from personal circumstances or from conditions common to the neighborhood or the general public may not be used as a basis for granting a variance. I need a motion.
Read that again, please.
The hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances or from conditions common to the neighborhood or the general public may not be used as a basis for granting a variance.
I'm not gonna make all the motions.
No,
Well,
well,
I'm trying to,
going
Don't
through,
say
all-
that.
I mean, all four of them like this
Mm.
is difficult to come up with another motion. So, I motion that we deny because this does not present the hardship that is uncommon to the neighborhood, in my opinion.
and
Yeah. Can't add my opinion.
because they can get out at the back. Right?
But what you're saying is there's nothing particularly peculiar about the property that would warrant bending the rules, right? We talked about the setbacks and the.
He has access. He has
Talked about-
access.
Yeah, now,
Uh,
if his property had a retaining wall and the property dropped off 6 feet before the,
Or if the city had expanded the right of way to 8 feet in anticipation of an interstate exit. At the end of a dead end road, that is a very peculiar situation for a property.
peculiar situation. We didn't have-
This, when you got plenty of yard to work with, is not peculiar, right?
And I don't have the evidence of the setback of the other houses.
Exactly. And that's a condition that's common to the neighborhood, which can't be considered in granting a variance.
So, Mr. Chairman, would you repeat that motion and the reasoning for it?
You're killing me, Ike.
We're just doing practice. Just practice here.
That's
You guys are doing good.
Mr. Poe, would you elaborate one more time, please?
I'm gonna have to write this down. We're gonna start writing this stuff down.
Oh, wait, that's good. We just practice and I'm messing with Ray.
He's doing a
You
great
know.
job.
Let's vote on
All right,
Trial by fire.
it. Let's see, is there a second? I'll second the motion.
all right. So all those in favor signify aye.
Aye.
Opposed, no.
Always ask for any more discussion
Is there any more discussion?
before we vote.
Okay. All those in favor signify aye. Opposed, no.
Let the vote show.
Unanimous. So that brings us to item 3.
Yep.
The hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge of the circumstances does not create a self-inflicted hardship.
So is that never done anything yet? Like, with the house, did they do anything with it? I know last year we was talking about it.
Yeah, no, they've not, and according to the scenario we're working through, the house, the footprint of the house has not changed since they purchased it.
Oh,
Yeah, they haven't.
So therefore,
So in this scenario, you're gonna ask yourself, did the hardship result from actions taken by the applicant?
yeah, and that's.
And what is the
that's a-
action?
That's an obvious answer.
So what's the action taken by the applicant? They want to put an addition on the front of their house.
yeah.
Right.
Yeah.
If the action was put an addition on the back of the house, where there's no problem, we wouldn't even be here.
That's right.
Right.
Exactly.
Okay?
Yeah.
So is there any further discussion?
No, you need to
They
do
need
that
to
after
just
the
forget
motion.
about it.
You need to ask for the motion first.
Okay, so
And then once a motion and a second's made, then ask if there's any further discussion.
got you.
I make a motion that the owner did not do anything that would create this hardship on his accord.
We have a motion. Do we have a second?
I'll say.
Is there any further discussion?
Could you repeat that motion? Cause my brain is flipping it here from what I'm thinking it ought to be.
Motion is that, the owner did not create the hardship on his own accord. That it was a pre-existing condition.
Because he bought the house.
That's correct.
It was already there.
As is. No further
Mr.
construction.
Conlon, would you read that question again? For us to discuss it again?
The hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge of the circumstances does not create a self-inflicted hardship.
So he knew the house was where it was when he bought
Correct.
And the action he's taken again is applying to build on the front of the house.
That's right.
Encroaching in the setback.
And he's already been there 40 years.
That's the action being taken here, yeah.
Yeah.
Again, if he were building on the back of the house where he has plenty
it. No
of space,
question.
we wouldn't even be here.
Okay, so we have a motion. Do we have a second?
I'll second.
Is there any further discussion?
It's like Groundhog Day.
All those in favor signify aye.
Aye.
Opposed, no. Unanimous. All right, so that brings us to item 4. The requested variance is consistent with the spirit, purpose, and intent of the regulation so that public safety is secured and substantial justice is achieved.
Make a motion that, the variance request is not consistent with the ordinance.
I'll second that.
Is there any further discussion?
I disagree. I think that how do I want to say this? That the intent and spirit of the ordinance is to have a good space between the residents and the road. And this clearly does because he's more so than all his neighbors. And so therefore, it, what I want to say, he has no control over that. That the spirit of the rule has not been encroached upon.
And to my point is that he hasn't proved that with documentation that those homes are actually, because what I see.
We do have documentation. We have the plats right here.
Just
that I
just for
see,
his property,
Right.
that,
not the
the only
adjoining.
one that I see is that nobody on his left, and this one here is not encroaching under 30 feet. That's all I see. Now, if he would have brought me additional plats of different homes that's in the neighborhood, I did not look it up on GPS. or,
GIS.
the GIS, and look as an overview. If he would have brought me a map like that, maybe I would have, changed my opinion to a
Okay,
degree.
well, right here on the,
However, there is no, provision in the existing ordinance for any grandfathering in. If we were talking maybe about an inch or two or three, maybe see even more, a little sympathetic on it, but 5 feet is not within the spirit of the ordinance.
all right, so if you'll continue looking at this plat, the, lot, we're gonna call it lot number 9. That existing dwelling is 34.8 feet off the road.
Now, that's to Mr. Poe's point. There was nothing presented to us to prove anything different, other than I did look at the GPS and it looks like some of them are closer, but there's not, we can't take that into consideration
No
because of, that's right.
Okay. So we have a motion and a second.
Well, before you proceed on this too, I think it's worth pointing that they may have an argument to make for item number 4, if their argument were a little bit different. If there was a more pressing need for them to build onto the front of the house as opposed to the back. If there was some type of a conversation, especially if there was expert testimony from a contractor or another professional that said, you know, I recommended them to do a 10-foot entrance. But they said they wanted to comply with the regulations as much as possible, so we dialed it down to 5 feet 1 inches. Right? Or if there were a more serious impairment with regards to the health of the couple, that type of thing, and you get into safety issues. They may, if that was their argument, they might have a more compelling.
Exactly.
a
But
more
that's not
compelling
the case.
case for number 4. And,
But I agree with you.
and if they do make that argument and you grant them you grant them approval based on criteria number 4 alone, still
That's
doesn't
not gonna
pass
work.
because it has to be all 4.
Yeah.
Can't just be one.
We got to be yay
Right.
on all 4.
Exactly.
So it's already failed.
Yeah.
We're,
So I think you guys made some really good points regarding item number 4 there. They probably just need to make a little bit of a different argument if they're gonna prove that to be the case.
so we never voted on number 4, I don't believe. We're discussing. It's all,
So we have a motion and a second.
yes.
All those in favor signify aye.
Aye.
Opposed, no.
No. There you go. That's what we need. Somebody vote
So
yes.
item 1 was 4 to
1.
1 to deny. Item
Correct.
2 was unanimous to deny. Item 3 was unanimous to deny, and item 4 was
4 to 1.
to deny.
Yes.
And
The
now,
variance is
Mr.
not
Chairman,
granted.
I'll be, Mr. Chairman, I'll be glad to make a motion that we deny the variance request based on our findings.
Okay, we have a motion.
And I'll second.
All right, we have a motion and a second. Any further discussions concerning this issue? All those in favor signify aye.
Aye.
Opposed, no. Motion carries unanimously.
I'm pretty good there, old boy.
I'll learn one day.
You doing pretty good.
Matthew, what else do you have for us?
All right, so now let's get on to the mock administrative appeal. All right, so Mr. Belcher has come and gone. He presented his variance case to the board. Took a long time to deliberate. That chairman seemed like it must have been his first time doing this or something. And
Or
so,
long-winded.
yeah, and
Some
so
of
he
it's gonna
comes
be
back.
long.
We have to be thorough.
And so he comes back to the county. He's got a different property out in the county. Outside the neighborhood, totally on the other side of the county, it's about a 31 acre property. And we denied his request to subdivide this property.
That's just,
And that is
Mhm.
that packet begins with this document right here.
Got it.
So, Mr. Chairman, the Belcher family is appealing my administrative decision to deny their proposed division of land on their 31.17 acre parcel, which is along Highway 49 South in the Coble Township. In my letter to the Belchners, I stated the following. Dear Mr. and Mrs. Belcher, I have decided to deny your application to divide your property because your previous activities related to a different property that you own, because of your previous activities related to a different property that you own within the county. On that property, you requested a variance in order to build a new entryway into your home, which would have encroached 5 feet into the front property setback. The Board of Adjustment denied your request. However, the process of hearing the variance request required a lot of staff time and a lot of board time and came at great inconvenience. With this proposed division of the new proposal to divide your property, I'm afraid that you will once again tie up a great deal of staff time and possibly board time. Therefore, I am denying your preliminary plat. Sincerely, Matthew Hoagland, Alamance County Planning Director. With that, Mr. Chairman, I'll be glad to answer any questions that you might have in this appeals case.
Mr. Hoagland,
Yes, sir.
is this an honest opinion, or are we being vindictive because Mr. and Miss Belcher came over here before and they got turned down?
I'm being very vindictive. This is a slam dunk case and you should rule against me as fast as possible.
I'd probably say it like this. You telling me that Alamance County
Yeah,
ain't got time enough to hear this?
yeah.
I'd get strong language on that.
Well, Mr. Hoagland, did you go to the liquor store before you come in here? I know you just presented this to us.
I did not.
So you just drunk all the time, is that right?
Just drunk with power.
Yes, sir.
May I make a motion to dismiss this, variance denial from the county?
All right, we have a
No,
motion.
no. You can't do that yet.
Okay,
You got to go through 4 questions.
okay.
No, only for a variance.
Oh, well, that's right. That's right. This is not, this is administrative. Sorry. That's right.
So we have a motion. Do we have a second?
I'll second.
Any further discussion?
So I'll just throw this out here. You don't have to take it any more time on this if you need to. It would be good to hear from the appellant. And in this particular case, what I would try to find out is this plat otherwise approvable? Has the surveyor drawn it up according to specs? Does it meet everything else required in the subdivision ordinance, so on and so forth? Is it formatted correctly? If it is an otherwise approvable document or permit or whatever, then that leads you directly to your conclusion. Your ultimate answer is, Mr. Hoagland, you need to reverse your denial. You need to process this. We're going to order you to process this in accordance with the normal provisions of the.
All right, so we got a motion second on the table, but at the same time, Mr. Belcher, you can take your glasses off now.
Yes, sir. Yeah, thank you. Good to see you guys again. I really hate that you didn't approve me on that last one. We put in a paved drive to the back of the house and it cost me $20,000. So thanks, guys. Appreciate that.
Well, you know, Jenna Craig would have been cheaper if you just sent your wife over to see her. Okay, Mr. Belcher, what's your opinion on this? Talk to us.
Thank you, Mr. Chairman. I'm here to give notice that I am submitting an appeal over the decision to deny the subdivision of land. As Mr. Hoagland stated, I was denied the right to subdivide the land and to build a home on the property, after the property was subdivided. I've had the reason was that I've had complications with past projects and that this project could also possibly cause unwanted complications. I don't see how this project causes any unwanted complications. We hired a licensed North Carolina surveyor to draw this up, who has done plenty of work in Alamance County over the years. We can share with you plats that they've had submitted and approved to the county before that are very similar to this. He has told us that he's placed all required certifications and everything needed on this plat to be approved. Otherwise, just in this particular case, Mr. Hoagland denied us because I think there was just so much frustration with the variance that we requested previously. So we respectfully ask that you reverse Mr. Hoagland's determination and that you ask county staff to proceed normally with processing our subdivision plat.
Do you have questions for Mr. Hoagland?
Please, sir, go ahead.
Does this survey, Richard Glass,
Yeah.
does this survey meet the subdivision standards for road frontage?
Yeah, with regards to road frontage and lot size and all the other dimensional standards, this is an approvable plat.
Thank you.
Well, Mr. Hoagland, why did you deny?
Well, like I said, I mean, I'm really looking out for you guys here. You know, the variance case took so long last time. I was just afraid something more quirky would happen with this, and it ties up a bunch of staff time, ties up a bunch of board time, and I just didn't want to put the county through that headache. So I thought it'd be better just to say, nope, sorry, and Mr. Belcher would go away. But unfortunately, he submitted this appeal, and here we are again.
So he submitted this appeal and we're not at home having chicken casserole and watching the ball game, right?
That's exactly right.
We have a motion and a second. Is there any further discussion that we need to be thinking about?
Let's see now, a aye vote would mean if we're going to instruct the planning staff to readdress Mr. Belcher's
Well,
subdivision.
after we have this vote, I got one statement I'm gonna make to Mr. Planner over here. All those in favor signify aye.
Uh,
Opposed, no. Motion carries. Now, Mr. Hope,
Yes, sir.
you gonna wanna get this subdivision requirement, approved for these people? Or we're
Yeah.
gonna talk to the commission, we're gonna get you fired right at the whole river.
We're gonna send you back to Caswell County.
That's right.
Yeah, do that. All joking aside, though, the reason that I came up with that rather ridiculous example is if we ever get to that situation where I have approved or denied something and the appeal comes before you guys, if the right thing to do is to disagree with me and
Oh, yeah.
overturn that decision,
Of course.
then you need to do the right thing.
Yeah.
Okay? I don't want you guys to think you're gonna hurt my feelings or I'm gonna have some, case of animosity or anything. You guys do what you think is right.
We know who's the chief and who's the Indian.
All right, so I appreciate you guys.
Do I
Well,
need
go.
to sign for those rule updates?
You sure do.
That's what I was thinking.
This is the,
Can I have a sync pen? It sure does right.
it is nice, isn't it?
And it sure does right. Good.
That is the final copy with the amendments incorporated. So you'll notice there's no strike through or underlining there. It just incorporates what you guys already voted on.
Okay. Oh,
Yeah, if you don't mind going ahead and signing that. The last page. So while he's doing that, any other questions or comments or thoughts?
Well, my question to you is, what that fellow from Greensboro wind up Hall River for? I mean, that is a demotion if there's ever been one.
I think Sean's happy in Fall River.
I could be sure to read that last sentence right there, but you're taking us all out to eat tonight after the meeting.
gotcha.
I like the way he's thinking.
Gotcha. Let's see, today is July 17th, 2025. Well, I'll take back over as chair. I'll be glad to entertain a motion to adjourn.
So moved.
Any second, any discussion?
No, sir.
Hurry up.
All in favor, say aye.
Aye.
Good to see you guys.
Good to see you too, Ike.
You did a good job.
Well,